The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is now sitting for the dispatch of business. God save the state and this honorable court.
Good morning. Our first case is the Cheryl Lloyd Humphrey Land Investment Company, LLC versus Resco Products, Inc. et al. And we will hear from the appellant.
Thank you, Mr. Chief Justice, and may it please the court. I'm Brad Cutro, and I represent defendants Resco Products and Piedmont Minerals. This is a case of first impression. It requires this court to consider the protection that's guaranteed by the First Amendment's right to petition to a petitioning speaker addressing a public body, Hillsborough's Town Board, at a scheduled public meeting about a rezoning that public body was then deciding. The right to petition the government for redress of grievances is one of the rights guaranteed to the people by the First Amendment, and it's co-equal with others: speech, press, assembly, and religious freedom. Yet the petition clause is less often the subject of litigation, perhaps because the right to petition is so deeply rooted in our history. But in this case, the Court of Appeals failed to recognize how the First Amendment and its petition clause protected what the parties all now agree was my client's petitioning speech. In this court, the parties agree that some extent of petition clause protection applies here. Petitioning speech by citizens speaking in person to public officials is historically what the framers had in mind, more than litigation and lobbying, although those activities are now plainly protected as petitioning speech as well. Petitioning speech is at the very center of the First Amendment's protections for political speech because it's central to the purpose of the First Amendment, guaranteeing citizens freedom to speak about, criticize, publish about, and petition the government for action or inaction, and allowing common law tort claims by those who disagree with a citizen's viewpoint expressed in petitioning speech at a public meeting would jeopardize that freedom and violate the First Amendment. The risk of common law tort liability, especially for a tort claim as amorphous and ill-defined as tortious interference with prospective economic advantage, would inevitably impact and chill citizens' willingness to speak at public meetings, whether those citizens are individuals or businesses. So I'd like to make 3 points this morning. First, the petition clause extends absolute immunity here, where a speaker is addressing public officials in a public meeting and where there are no antitrust concerns. In that setting, petition clause protection goes beyond the scope of the Norr-Pennington doctrine. But even applying the Norr-Pennington analysis, and here I'd point the court in particular to the Seventh Circuit's Mercatus case and to the Supreme Court's City of Columbia case, Resco and Piedmont Minerals are immune from common law tort liability for their petitioning speech because it was not a sham petition under those cases. And apart from that immunity, plaintiff's complaint does not state a claim for tortious interference with prospective economic advantage here because the comments concerned things that might happen in the future, not current or past or existing facts, and because the comments were justified when they were made, and then Humphrey Land was able to successfully negotiate and reach a contract with the developer to purchase the land in question. And that was obtained after the petitioning speech. So although this is a case of first impression, the court has ample guidance from the federal courts that have decided analogous cases. Applying the principles from those cases, this court should conclude that my client's petitioning speech explaining to the Hillsborough town officials how a proposed annexation and zoning would impact their mining operation is immune from plaintiff's common law tort claim. Now, to step back, the right to petition is part of the First Amendment, which is part of the Bill of Rights, which is part of the Constitution, our nation's bedrock law. The Norr-Pennington doctrine is a court-created doctrine developed in cases where there was litigation between two competing businesses or between a business and its employees. Norr-Pennington was developed to sort out and differentiate legitimate civil claims from illegitimate anti-competitive conduct. But it's never been held that the protection of the First Amendment's petition clause is limited only to the antitrust context. And that's where the Court of Appeals took the wrong path. The Court of Appeals failed to recognize that the petitioning speech here by a corporate citizen speaking at a scheduled meeting of the Hillsborough Town Board and Planning Board is the paradigm of petitioning speech to government officials as it's been understood since the time of the framers of the Constitution.
Mr. Kitro, as you, I think, have already indicated, I'm not under the impression that there's any difference of opinion between the parties at this point as to whether the Court of Appeals was correct in limiting the Pennington doctrine to antitrust cases. In view of the fact that we have an agreement on that question, and now Mr. Steele and Mr. Broad can contradict me if I'm wrong, but I don't think I am, what really do we need to decide in this case?
Well, Your Honor, I think this is this is an important chance for this court to address a question of first impression under the United States Constitution and to provide important guidance to parties that appear in public meetings and engage in petitioning speech. And although the Court of Appeals, I think by all parties and by the Solicitor General's estimation, erred, we think that it's important for this court to address these issues now that they're properly framed before it. I'd also point out
and I don't have any doubt that we need to address the issue of whether the Court of Appeals was correct. I think the question that I'm struggling with is, assuming that the Court of Appeals was incorrect and that there is constitutional protection in this area outside the antitrust context, what is the scope of that constitutional protection and how does that protection apply to the facts alleged in the complaint, since this is here on, I think, a 12b6 motion?
Well, let me try to address that, Your Honor. And the other point I'll make here is that this case has already been through the trial court where Judge Afalou dismissed it on the 12b6, been to the Court of Appeals, now it's before this court. And frankly, I think that's one reason why the parties would like to get as much clarity as they can from today's argument. What we argue is that in this specific setting of a public meeting governed by the Open Meetings Law, there should be an absolute immunity for petitioning speech, because that is a unique environment that's subject to special assurances and has structural safeguards that really minimize any risk of false or inaccurate speech. And I think the trade-off in that specific setting needs to be made in favor of petitioning speech. So let me go directly to that point, and then I'll also address, if I may, the Noor-Pennington doctrine and why I believe the dismissal was also appropriate under the Noor-Pennington doctrine, as it's been articulated, even in cases where there is some antitrust concern, there are antitrust concerns which are not present here. So
as you get ready to go through this, should we listen to this through the prism of the fact that this is ultra hazardous activity, or does that make a difference?
Well, Your Honor, I think it makes a difference and we argued this in the trial court, Justice Morgan, that it is an ultra hazardous activity. It is, as a matter of law, dangerous and unpredictable. And again, that is all my clients were trying to point out, is what might happen in the future if this townhome development was brought in such close proximity to the mine. Now, plaintiff's point is that our mining operation had not previously had any sort of permit violation. That doesn't answer the question necessarily of what might happen in the future when occupied structures are brought closer. It also doesn't account for the fact that it's an additional burden on our mining operation. By the way, this is very close to the center of the town of Hillsborough. It's less than 2,000 feet from the Orange County Courthouse. When structures are brought closer, that imposes burdens on our client would in the future to monitor seismic impacts, to conduct monitoring of blasting and that sort of thing. So I think the ultra hazardous nature of our activity can be considered, and that's what we argued, is that justifies the petitioning speech in this conduct.
Go ahead, Justice Morgan.
Oh, thank you. Just to follow up, I didn't want to derail your flow, but I did not know if the fact that this was ultra hazardous activity, which has been represented as being the type of activity that cannot be excessively misrepresented or represented to such an extent that we needed to look at this as a court through the prism of it being ultra hazardous activity, or as you're saying, if it is ultimately absolute immunity, whether that made a difference at all, the kind of activity it was. Are you saying it does not matter because it's absolute immunity regardless?
I would make that argument, yes, Justice Morgan, because I think the public meeting setting is a unique setting in our democracy for petitioning speech. And let me just identify a few of the reasons why I think that's true. Again, this is about speech at a public meeting before a public body governed by the open meetings law. And it's a special setting where we submit speakers should be immune from common law tort claims. And our reply brief points out several structural safeguards exist. Again, these meetings are governed by the open meetings law, so they're required to be held at a time and place that's disclosed to the public and interested parties. And proponents and opponents of a proposed action by the public body can be heard and provide their different perspectives. And any factual inaccuracies, which is, I think, the concern here as articulated by the plaintiff and to some extent by the Solicitor General, factual inaccuracies can be challenged and corrected in real time. That's why we hold public meetings.
So, Mr. Petro, then your argument is that it does not matter for purposes of the absolute immunity that you're asking us to recognize whether the statements that were made were true or false?
Well, I think in this unique setting, Justice Irwin, let me address that in two pieces. In this particular setting, I think the balance ought to be struck in favor of the right of petitioning speech, because there is a minimal concern in this particular setting about false or inaccurate speech. I think, as I've said, it's can be corrected and challenged in real time. The town board is elected of multiple members, like virtually all of our public bodies, and they're elected or appointed to critically evaluate that information. That's why we elect officials. And then, of course, almost every public body has professional staff that they can rely on to fact check and validate information provided at public meetings. In this case, the DEQ regulates mining operations, and that's another source of information. And then other interested citizens and the news media can attend public meetings to correct any factual misstatement. So what I would argue is that the risk of a misrepresentation or a false statement actually having a negative impact is minimized in that unique public meeting setting. But here, of course,
if I understand the Solicitor General's argument, and he and I will have some conversation about that in a minute, one of the things that he says we need to take into consideration is whether the public body is engaged in the legislative or adjudicative function. I take it under your argument that doesn't make any difference either.
Well, I think I would point out a problem, and I would also observe here, I think the town board's decision that it was making was legislative or political in nature. It was not adjudicative. It was not regulatory. They were making a decision that was within their discretion. So I would submit that that's political, and therefore there's extra room there under, for example, the City of Columbia and other cases that gives additional room for petitioning speech in that setting. I'd also point out that in this case, the allegedly false speech, which Mr. Steele's client, the plaintiff, has alleged was false, did not impact negatively, did not cause the outcome that he would say he feared, because the rezoning and the annexation was approved. And under the Mercatus case that we've cited, that means that there cannot be any liability for sham or false petitioning speech because it did not have the effect that the speaker was intending it to have. To the Solicitor General's point about, and certainly we would concede that the Solicitor General and the government have points that are worthy of concern about the possibility of inaccurate or false information being provided to the government in a setting like, for example, the McClure case. But that's the government's lookout, first of all. The government has a number of different tools that it can use to deter and punish false information if it's provided to the government. That concern is not one that exists here, and it's not one that's well served by creating civil tort liability brought on behalf of third parties rather than the government. And then finally, Your Honor, as we pointed out in our brief, I'll just say that it's not always going to be readily apparent to a citizen speaker that whether a particular proceeding is legislative and political or adjudicative or regulatory. I do think there are important ways that the government can assure that it gets correct and reliable information in those settings. For example, it can require that testimony be submitted under oath. For example, I think there's testimony under oath even and written testimony under oath in the Utilities Commission. It can require verification by affidavit or some other means. There are lots of ways that the government can assure that the speech that's provided to it is accurate and reliable. And I think, again, here, the setting of a public meeting involving a citizen speaker is one where there ought to be a great deal of petitioning, of leeway and freedom from civil liability for petitioning speech.
Is there any decision of the United States Supreme Court that holds in accordance with the argument that you're making directly?
Directly, there's not, Your Honor, because I don't think this kind of case has ever gotten to the U.S. Supreme Court. Because again, the petitioning clause comes up almost entirely in cases where there is some risk of anti-competitive conduct or antitrust. I would point the court to the City of Columbia case and Justice Scalia's opinion there, which did involve substantial concerns about anti-competitive behavior. And even then, Justice Scalia and the court held that if the petitioning speech was objectively reasonable, meaning that it was the kind of speech that could potentially have been successful, and more importantly, if there was no indication, and there's no indication here of a consistent, repeated attempt to essentially use the process of government consideration of some measure as opposed to the outcome to achieve an end, that is the crucial distinction. And here there's no evidence that my clients used the public meetings before the town board as a weapon to delay, impair, prevent consideration of the plaintiff's petition for rezoning and annexation. In fact, that petition was approved. The entire development was ultimately approved by virtue of the town board and planning board's decision. So I would point to the City of Columbia case as the U.S. Supreme Court case that most closely would hold that this action should have been dismissed, that the dismissal by Judge Oppalu in the trial court should be sustained.
Can I ask you to address, assuming that we don't agree that the petitioning protection under the First Amendment is absolute, that it applies here, but it's not absolute, that there are exceptions for sham petitions or for misrepresentations, wouldn't the allegations of this complaint, which at the motion to dismiss stage we are taking as true, wouldn't the allegations in paragraph 38 essentially allege a sham petition in this particular case?
Well, I think you need to look at the entire complaint in context, Justice Earls. First of all, the alleged misrepresentations here that have been labeled false, certainly in the complaint, concern potential future events, what might happen in the future if this rezoning and annexation were permitted. Now, that's not traditionally been the basis for a misrepresentation claim. In other words, future events as opposed to a present or existing fact. But here we have essentially a misrepresentation claim wrapped in a tortious interference with prospective advantage claim. But the other thing, and I would point the court in particular to paragraph 27, and this is at record page 14, it said, during the course of the meetings before the town board and after extensive questioning, the defendants conceded that they could in fact conduct their mining excavations without endangering the citizens of the development as they were required to under the permit, but that in order to do so, they would have to take additional safety precautions, which would cost them more money. So, Your Honor, my point is that by the complaint's own allegations, any concern raised by these comments that there might be danger to the residents of the townhome development was corrected in that same meeting. And the conclusion, or the board was informed that in fact the operation could be conducted safely with these additional safety measures. And on that basis, I would submit that the complaint itself pleads that the town board had correct information before it, even though the label false has been applied in the complaint. The other thing that I would point to, Your Honor, if you will look at the Mercatus case, it makes the point that even applying the sham doctrine, the speech is protected and cannot be the basis for civil tort liability if it did not have the desired effect. That is to say, if the town board itself was not misled, because the concern under the petitioning speech is protected unless it poses the risk of misleading the government. And I think Mr. Broad for the Solicitor General will speak to this shortly. It's not these carve-outs to the petitioning speech right outside the antitrust context are meant to protect the government's interest in getting good information. They're not meant to create a basis for third parties to bring civil tort claim against a petitioning speaker who's only speaking to his or her government representatives. And in the Mercatus case, you'll recall there was a proposal to build a new physician center in a community that was already served by a nonprofit hospital. The existing hospital opposed it because it thought it would hurt its business. Mercatus, much like the plaintiff here, argued that the hospital made misrepresentations that altered the outcome of the village board's meetings, and that was why the board denied the approvals that the new physician center needed to start construction. But the Seventh Circuit rejected that. It held that even if it assumed that the hospital made misrepresentations, those were legally irrelevant because the meetings were political in nature, which meant that they got additional petition clause protection, and the board's discretion, like the town board's decision here, was discretionary. So it held that the comments to that board were...
Counsel, you can continue, but you're well into your rebuttal time the way I'm reading.
You're right, Your Honor. Thank you for the reminder. I'll reserve the rest of my time for rebuttal.
We'll hear from the amicus at this time.
Mr. Chief Justice, and may it please the court, Nick Broad, I'm Assistant Solicitor General, appearing for the state as amicus curiae in support of neither party. I'd like to thank the court for allowing us to participate as an amicus in this appeal, and I'd also like to thank the parties for ceding some of their time to us this morning. The state is appearing as an amicus in this case for two main reasons. First, the state seeks to protect the right of all individuals to petition their government in genuine ways without facing the threat of liability for what they say. Because the decision below undermines that right by incorrectly limiting petitioning immunity under the Noor-Pennington Doctrine to antitrust and unfair competition claims, the state respectfully requests that this court reverse the decision below. Second, the state also seeks to ensure that petitioning immunity is not absolute, particularly in non-political contexts where state and local governments cannot function effectively if parties do not tell the truth. Although the state has taken no position on how the Noor-Pennington Doctrine might apply to the facts here, the state respectfully requests that the court make clear that petitioning immunity is not absolute and that private parties do not have automatic immunity for allegedly false or otherwise sham petitions to government bodies acting in non-political contexts. I'm happy to take questions at any time, but absent questions, I have 3 minutes.
I'm going to take you up on your invitation as I previously threatened. I've looked at your brief, and basically, when you get to the second issue, which is how do you apply the test, you essentially ask us to think about several things, but I'm not really sure what we do with what we decide after we think about it. And for example, you make a distinction between legislative and adjudicated proceedings. Are you suggesting that, assuming that we were to decide that a particular proceeding was one or the other, what do we then do? Do we say, for example, if it's legislative, that's the end of the inquiry and we stop, or do we do something else?
Your Honor, that's right. If the court concludes that a case involves a political context or a legislative context, I think in that situation, Noor-Pennington immunity is very, very close to absolute. It's hard to imagine a case in which a court would allow a private party to be liable in tort for petitioning activity in a political or a legislative context.
Is there any basis for concluding that the present proceeding in which these statements were made wasn't legislative or political?
Your Honor, so I want to make clear that the state has not taken a position on the facts of this particular case. We do think, though, that the Mercatus case is sort of a model that the court could follow in conducting the analysis of whether a context is political or non-political. I think the value of the Mercatus case is that it sets out 5 non-dispositive factors, non-exhaustive factors that might help a court differentiate between a political context on the one hand and a non-political context on the other. Because in a non-political context, the calculus is totally different. In a non-political context, the petitioning right is not absolute, and it gives way to important countervailing government interests in protecting.
Would the method of analysis that you're recommending call upon us to first of all ask the question, is it legislative or adjudicative? If it's legislative, we stop there and say there's no liability. If it's adjudicative, we then look at these other factors of, one, whether the sham exception exists, or secondly, whether there was a material falsehood. Is that what you're suggesting that we do in that order?
Yes, Your Honor. Yes, that's exactly right. We think the threshold question in any case is whether the petitioning activity takes place in a political or a non-political context. And if a court were to conclude that the petitioning activity took place in a political context, that, for all intents and purposes, ends the inquiry, and Pennington immunity would apply.
Can I ask you to articulate how McDonald versus Smith coincides with that theory? Because in that case, the court found that there could be liability for speech that was in a political context.
Your Honor, as I said to Justice Ervin, and I want to make this clear, I don't think that there's any sort of bright line rule that can ever apply. I think it's very difficult to imagine a case in a political context in which an individual could potentially be civilly liable for.
But that's the case. McDonald versus Smith is the case.
Well, Your Honor, I think McDonald against Smith may be a little bit different because it involves a defamation claim rather than sort of the typical scenario where you see Norr Pennington come into play, which is either antitrust or other types of business tort claims. I think McDonald against Smith, at least from our perspective, is useful in thinking about why the petition right is not absolute in all contexts, but it may not exactly fit with the facts of this case, which don't involve allegedly defamatory speech. But I think this political versus non-political distinction is really getting at is the proceeding the type of proceeding in which there is an expectation that parties tell the truth. And in a political context, I think as a general matter, the Supreme Court has recognized that there is not that kind of expectation of truthfulness. Whereas in a non-political context, government bodies at all levels rely on parties to provide truthful information. So just to give you a couple of examples, I mean, the paradigmatic non-political context is a court proceeding in which individuals, take an oath to tell nothing but the truth. You can imagine all manner of different agency adjudications or agency investigations. A non-political context could also include, for example, testimony under oath before a legislative committee. I think those types of cases are where there's a critical state interest in making sure that the state can protect the integrity of government decision-making. And I think, Exhibit A for this point is the McClure case, the business court case that we cited to the court in our amicus brief and that the parties have discussed. In that case, the defendants allegedly submitted false information to a state agency and allegedly rigged bids. The business court in that case held that Norr Pennington immunity was not, in fact, available on the facts of that type of case. And I think it's easy to imagine a number of similar scenarios that could arise if the court were to hold that Noor-Pennington immunity was absolute, even in a non-political context. I think there's another critical government interest that comes into play in non-political contexts that counsels in favor of a holding that Noor-Pennington immunity is not absolute, and that's the government's interest in protecting competition and protecting consumers. A very common example that arises in this setting is an allegedly sham lawsuit that might be filed by a party with market power in an effort to, delay a competitor's entry into a relevant market or otherwise impose costs on a competitor. So I think these two critical government interests, the government interest in maintaining the integrity of government decision-making on the one hand, in addition to the government interest in protecting competition and protecting consumers, are the reason why the petition right in a non-political context is not absolute, is narrower, is subject to the sham exception and the misrepresentation exception that the court discussed earlier with Mr. Tutro. Whereas in the political context, I think it's a very different landscape. As I discussed with Justice Ervin, I think in that situation, in a political context, it's tough to imagine a party being held liable for genuine petitioning activity, because I think courts are reticent to decide in political context, what speech is true and what speech is false. Political context is typically a situation in which individuals are debating matters of policy. They're making forward-looking predictive judgments that really can't, in any real sense, be true or false, at least in a legally cognizable way. Whereas in the non-political context, oftentimes you see parties making representations of historical fact that courts can in fact decide whether they're true or whether they're false. In sum, the state respectfully requests that the court reverse the decision below, but make clear that Noor-Pennington immunity is not absolute, particularly in non-political contexts. And I'd like to thank the court again for allowing us to be here this morning. Thank you.
Thank you, counsel. We appreciate your willingness to participate. We thank the Attorney General. At this point, we'll hear from the appellate.
Good morning, Mr. Chief Justice, Associate Justices. My name is Charles Steele. I represent the plaintiff, Appellee Lloyd Humphrey Land Investment Company, LLC, in this proceeding. I'll begin by emphasizing what I think is the most important point in your consideration of this case. Namely, this is an appeal from a dismissal by the trial court in Orange County pursuant to Rule 12b-6 of the Rules of Civil Procedure, failure to state a claim upon which relief can be granted. The plaintiff, appellee, filed a complaint. The defendant, appellant, filed a motion to dismiss. After submission of briefs and oral arguments, the trial judge dismissed the complaint for failure to state a claim upon which relief can be granted. There's been no discovery, no evidence presented. The court is called upon to decide whether the allegations of the complaint, if treated as true, are sufficient to state a claim upon which relief can be granted. The court is required to treat all factual allegations of the complaint as true and deemed admitted, and in a light most favorable to the plaintiff. The brief of the defendant appellant cites characterizations by the Court of Appeals with respect to factual allegations that are not based on any evidentiary findings. I would stress to the court in determining whether the case was improperly dismissed by the trial judge, the only facts that can be considered are the allegations in the complaint presumed to be true and admitted for this purpose. I would also acknowledge, as we've mentioned earlier, that the finding by the Court of Appeals that the Noor-Pennington doctrine only applies in antitrust cases is inconsistent with the United States Supreme Court holding in Snyder v. Phelps and numerous United States Court of Appeals opinions. However, for the following reasons, the plaintiff appellee contends the Court of Appeals was correct in its decision overturning the order of dismissal granted by the trial court. First, the defendant appellant's reliance on the immunity granted by the Noor-Pennington doctrine is misplaced in that such immunity is not an absolute, and the facts pled in the complaint clearly demonstrate the applicability of an exception to this doctrine. Secondly, Plaintiff appellee has correctly alleged a claim for tortious interference with prospective economic advantage, and the reasoning of the Court of Appeals issue is correct and should be affirmed. And defendant appellant's First Amendment arguments are not consistent with established legal precedents, and defendant appellant's claims that their representative speech before the town council was objectively reasonable is simply not supported by any factual basis and is specifically refuted by the allegations in the complaint, which must be assumed to be true and admitted. The Noor-Pennington Doctrine protects a private party.
Let me just very quickly. So is it your position that this was a legislative / political context for where the speech was given?
Your Honor, I believe it's a town council deciding a zoning map. So yes, political / legislative is probably an accurate characterization of this proceeding. So while you stopped a second, Mr. Steele, let me get to what I suggested to you that I might in a minute. Is your argument in essence that anytime there is an allegation that a false representation has been made in the course of a petitioning activity that immunity is not available? Yes, Your Honor. If that case has been dismissed without any evidence and in a situation where the allegations in the complaint must be presumed to be true and admitted, I think that's the only result that can be obtained. Okay, so I'm going to state what I think you just said in my words, and I want you to tell me if I'm right or not. And it's perfectly okay to tell me that I'm not right. I just want to make sure that I'm understanding you. I understand your argument then to be that regardless of context, in the event that a person engaged in petitioning activity makes a statement that in a complaint is alleged to be false, that complaint should survive a 12B6 motion? Yes. Okay. I mean, I always, my usual goal when we have these oral arguments is make sure I understand each party's position. And so that's why I asked the question. Thank you. And I, Your Honor, am accused by other lawyers of being too direct. So if my answer is too short and too direct, that's, nope, I understand your answer and appreciate its clarity. Thank you. The Noor-Pennington Doctrine.
If I may, I'm sorry.
Yes,
if I could just follow up on that point.
Yes, Justice Hudson.
Because so I want to understand your response to the defendant's argument that we have to look at the complaint as a whole, and that the statements that you are contending were false and therefore not entitled to immunity under Noor-Pennington were essentially corrected by other statements that were made in that very hearing.
I would, well, I think first of all, the complaint obviously needs to be looked at as a whole, Justice. However, I think the allegations with respect to misrepresentation must be taken as true and correct for purposes of considering whether the order granting the dismissal for failure to state of claim was properly given.
Let me ask a related follow-up. Does it matter if the allegations claim that there are misrepresentations that go to some end other than the proceeding at hand? Like here, the allegations are that the misrepresentations were designed to diminish the value, so the defendants could buy the property at a lower price. Does it matter the end to which the misrepresentations are aimed?
Well, I think, Your Honor, it speaks to the intention of the party and whether those statements were made in good faith or not. If there is an ulterior motive in making those statements, that clearly impeaches any attempt by the person making those statements that they're made in good faith.
Well, for purposes of immunity and application of this doctrine, is it required that the misrepresentations be to accomplish some end other than the government activity that's before the body?
I don't think so, Your Honor.
Okay, thank you.
Are we to take the position, from what I'm hearing you say, that your complaint is based, or your client's complaint is based upon the alleged falsity of the defendant's misrepresentations, to be a concession that Norah Pennington can be applied in a context outside of antitrust or market considerations?
Yes, Your Honor. I try to make that clear. We clearly agree that Norah Pennington can be applied in other settings.
All right. So as a result, we don't need to be concerned about what has been represented to be the Court of Appeals emphasis on the antitrust and consumer protection history of Norah Pennington. We can look at this in the context of political, legislative, and non-political and non-legislative forums such as this town of Hillsborough meeting.
In my opinion, yes, Your Honor.
Thank you.
The Norah Pennington doctrine protects a private party that uses proper means as an attempt to influence a public official or public body, but this immunity is not absolute. The United States Supreme Court has rejected absolutist claims to the Norah Pennington immunity in the case of Allied Tube and Conduit Corporation versus Indian Head, in the case of Donald versus Smith. Application of the Norah Pennington doctrine requires a balancing of two important legal principles. The Constitution protects the right to petition the government, but petitioners must be truthful in representations made to a governmental body. Private parties should not receive immunity when they make sham, request, or misrepresentations to a governmental body. The reason we have free speech isn't because everyone's views are right. It's because we try to reach the truth through a dialectic of competing viewpoints. An essential element of this process is a requirement that petitioners must be truthful in their presentation to any public body. For this reason, a private party should not receive immunity for sham, request, or misrepresentations.
Mr. Steele, I mean, you alluded to sham requests a couple of times. The Mercatus test, Mercatus case, at least as I read it, sets out a test for whether a sham exists or not. Are you suggesting that we ought to adopt that test for purposes of analyzing whether your complaint should survive the 12b6 motion or not?
I think the Mercatus case is qualified to some extent, particularly by the case of Donald versus Smith. I think there are other considerations that need to be put in there. That would be my opinion, Your Honor.
Well, all right, let me ask it more directly then. If assuming for purposes of discussion that we were to agree with you that in the event that you were able to establish that the petitioning activity was a sham, what's the test for determining whether a sham exists or not?
Actually, I'll get to that later in the argument, Your Honor. I can skip ahead and say in determining whether petitioning activity is a sham, the United States Supreme Court has set forth a two-part test. First, the petition must be objectively baseless in that no reasonable party would realize success on the merits. And secondly, the petition must be subjectively baseless in the sense that it attempts to use against another party. Petition for reason the town council did not find merit in the position presented by the defendant appellant. Also, as alleged in the complaint, the defendant appellant made an offer to purchase the subject property at a dramatically reduced price, indicating that its appearance and petitioning activity were merely an attempt to diminish the value of the property and purchase it for less than fair market value. So again, that two-pronged test, I believe, is what should be applied here.
Now, if I understand your complaint, and this is another one of these questions where if I don't understand it correctly, I want you to tell me to make sure that I'm reading the record correctly.
As I read your complaint, you in essence allege that the falsity was that fly rock and blast vibrations and things of that nature, it was false to represent that there was a risk that fly rock, blast, etc., would exceed the boundaries of the plaintiff's property because the permit prohibited the defendant from allowing that to happen. I'm sorry I didn't say that very well, but I hope you got the point. Is that correct?
That's part of it, Your Honor. Also, in the, I think it's 20-some years history of the operation of this mine, the defendant is required to report any incidents of that type. None have been reported.
Is it your contention then that it is that in the event that a permit prohibits fly rock from escaping the property or vibrations above a certain level from escaping the property, and because it's not happened in the past, that by itself is sufficient to show that the representation that the defendant made before the town board was false?
I don't think that in and of itself would be sufficient. We have an expert who will testify as to this type of mining operation and what's possible. And the defendant made very specific representations at the zoning hearing as to this is what could happen, what will happen if these houses are built this close to this mining operation.
Is there a difference between whether something could happen and whether it will?
Well, it depends on how it's used, Your Honor. It was used in this case to try and defeat zoning, to try and diminish the value of the plaintiff's property, and to cause the breach or the termination of the contract by the third-party purchaser.
What's your response to the argument that even under Nora Pennington, there's no liability here following recruits because at the end of the day, the permit was granted. So the petitioners essentially were not successful in their petition.
Well, I think they were not successful because the town council didn't believe what they were saying.
But wouldn't I guess the argument is that therefore means there can't be any liability for what they said.
Well, the liability here is for the termination of the contract by the third-party purchaser. This is a tortious interference with contractual relations case. And that party cited these statements made by the defendant's representatives at the town council meeting as the reason for terminating the contract and causing the plaintiff the loss of bargain under that contract. That's the actionable tort here, Your Honor.
So if I understand you correctly, you're saying what matters is not whether the petition itself was successful, but whether there was some other action that resulted that caused harm.
Well, I am saying that the statements made while they were not acted upon the town council were acted upon by a third party with whom the plaintiff had contractual relations. And that's the operative tort here, Your Honor.
Counsel, it's easy to get wrapped up in a case of first impression like this one, an interesting doctrine like the Nora Pennington doctrine, but I don't want to lose sight of the bottom line in this matter here, so I hope you can crystallize it. How is it that a 12B6 motion should be survived based upon your client's articulation of a claim upon which relief can be granted?
Well, Your Honor, you start with the fact that for purposes of a 12B6 motion, all of the allegations of the complaint are deemed to be true and admitted. So you have to look at the language of the complaint, and does that in and of itself state a cause of action? And I think in this case it does, Your Honor.
Okay, well, I understand that foundation. That's why I wanted to go to the foundation to have you to build on the foundation for this case in terms of what are the allegations that you feel in the context of this case have stated a claim upon which relief can be granted. In other words, plug in the allegations that you feel make such a claim.
Yes, Your Honor. In paragraphs 22 through 25 of the complaint, there are specific allegations of misrepresentation by the plaintiff appellant. Those misrepresentations, in our opinion, take this matter out of the North Pennington protection and make the decision to dismiss for failure to state a claim incorrect.
Does the fact that these are ultra hazardous activities play a role at all in terms of the ability to misrepresent something that is deemed to be ultra hazardous in our law?
Actually, I don't think so, Your Honor. I think the question is, did they misrepresent the activity, not the characterization of the activity?
So it's your position that ultra hazardous activity can be misrepresented, even though it is deemed to be ultra hazardous, blasting here being the only recognized ultra hazardous activity in our law?
Yes, Your Honor. I think the requirement of truthfulness exists regardless of the character of the activity.
Mr. Steele, if I could ask just a couple of questions, or give you a couple of scenarios. Our court is frequently faced with zoning issues. We had one that was brought to us where a chicken farm was concerned about a subdivision going in next to them, and all the different litigation that had been incurred by the agriculture community with regard to smells and feathers and dust and things like that. We also have seen situations where neighborhoods are opposed to an apartment complex or something like that, and the neighbors go in and speak at the public hearing. Under both of those scenarios, folks, neighbors could perhaps objectively be seen as overstating some of the disadvantages of the apartment. Certainly the chicken farm that maybe had had no complaints in the past could be said to overstate the dangers there, both of which would, after those statements are made, conceivably reduce the value of the buffer properties that would either protect the neighborhood or protect the chicken farm. What is the safeguard under your analysis? What is the safeguard that that all these folks would be potentially opening up themselves to liability? How can those folks who want to express for zoning, rezoning purposes, how can they be protected for being able to, as the public square would demand, they be able to express their views?
Well, I think clearly, Your Honor, in that circumstance, concerned citizens should be able to express their views. I will call the court's attention to this. The was not petitioning the town council for greater good of public for its own private gain to save cost and possibly purchase the adjacent property at a diminished value. There's a case in the Ninth Circuit, Clipper Express versus Rocky Mountain Motor Tariff Bureau, which holds that administrative bodies and courts rely on information presented by parties, and supplying of fraudulent or incorrect information threatens the fair and impartial function of those bodies. So again, I think there is a test of truthfulness still, even in the context of, Your Honor, a rezoning hearing. When
Again, a public square, a council, county commissioners, here you do have a more sophisticated entity, let's say, but is that even to be considered? I mean, are we to look at the sophistication? Okay, one of the neighbors is a lawyer, so we hold that neighbor to a higher standard than the other neighbor that's, retired. Certainly, those neighbors are about economic gain. They want to protect not just the peace of their neighborhood, but the value of their neighborhood. The same thing with the chicken farm with regard to its concern for being sued. Okay, that's economic. What is the test? How do you define the test of this is protected speech, but if you do this, then it's not protected?
Well, Your Honor, back to the basic principle of truthfulness. Is there a misrepresentation? Is this a sham presentation? And that's what the courts have held consistently in these situations. Ulterior motive. Is there a reason other than a public policy issue why this petitioner is present and asking this deliberative body to act in a certain way?
But couldn't that always be alleged? I mean, do the neighbors really want to just, I mean, so here you have an entity that's trying to protect itself from complaints in the surrounding area. The neighborhood, the chicken farm, they're trying to protect themselves from either complaints with the chicken farm or economic loss with the devaluation of their property. So I'm having a hard time trying to say that you say, and perhaps you've already answered this, that if the word sham or misrepresentation is in the complaint, then that survives the 12b-6, in which case, how is there any protection under this?
Your Honor, I would say this. There is, in this case, a direct correlation between a contractual relationship that was impacted by the petitioning activity. In the case of rezoning or such, there is an indirect, there certainly is impact on economic value and stuff, but not in the context, that's not a context interference with a contractual relationship that is caused by that petitioning activity, as there is here. So I think this is distinguishable from your typical zoning hearing, Your Honor, where neighbors show up and protest, which certainly happens all the time. If, let me see if I can resume here. The second cited issue is whether
you're down to your last few seconds. I don't know if you want to.
I'm done. Thank you, Your Honor.
Okay, thank you, counsel. We'll hear rebuttal.
Mr. Cutro, you're muted. Mr. Cutro, please unmute.
My apologies, Mr. Chief Justice. I'll try to make the best use I can of the time here, and I'll take the questions that the justice has raised in order as best I can. Justice Earls, to your question about McDonald, that's a very different setting. That was a gratuitous letter written by a lawyer to President Reagan to attempt to make defamatory comments about a candidate for U.S. Attorney's Office. It was successful in that setting, and I think the point of the Supreme Court's ruling there was the court was obviously in a defamation setting, there are a number of additional constitutional protections, including pleading protections at the 12b-6 stage, and the court was simply unwilling to extend additional petition clause protection beyond the array of protections for a defendant that exist in the defamation context. I think it's a very it's a very different case, and frankly, I think the more recent Supreme Court cases in the petition clause setting are much more favorable for the reasons that have already been identified during the argument. In response to some of Justice Irvin's points, I would point out that the 12b-6 situation, the 12b-6 procedural status here points out that unless there is petition clause protection given, and this goes to Chief Justice Newby's point as well, a citizen speaker is essentially vulnerable to prolonged litigation. We heard here about notice that there needed to be discovery, there needed to be expert testimony. A citizen speaker is not going to have the resources to be able to engage in that kind of prolonged litigation. That's why the petition clause allows this room, particularly in this public meeting setting.
Mr. Cutro, I have a quick question, I think. Do you agree that there's an exception to immunity for a sham petition?
So if you go to the North Pennington Doctrine, yes, there is. But if you look at the Mercatus case, this is not sham, or the City of Columbia case. This is not sham conduct. This was conduct about activity that was going to impact, or a potential zoning change that was going to impact our client. It certainly was not, as to quote City of Columbia, intended to gum up or leverage the process to achieve a negative, a self-interested outcome,
Don't we
as opposed to achieving the outcome itself.
Don't we look at the allegations of the complaint to see if they allege that there is some that kind of aim?
Well, let me say, if I may, the complaint doesn't allege anything about motive or this attempt to get the property for a lower price. In fact, if you look at page 96 of the record, the trial court said basically, why would they want this 5 acres? It's essentially worthless to them. Mr. Steele's response was they would buy it for protection so they wouldn't have any liability potential there. And I'll also point out that the fact that citizen or petitioning speech is economically motivated does not diminish its protection under the petition clause. And I would cite the City of Columbia case for that exact proposition, that the fact that a private party's political motives are selfish is irrelevant, because nor shields an attempt to influence public officials regardless of intent or purpose. I've only got 10 seconds left, so I will simply refer the court to our briefs and say again, we believe that the Court of Appeals decision should be reversed and the trial court's dismissal affirmed for all the reasons we've set out here today. Thank you very much.
Madam Clerk.
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina is in recess. God save the state and this honorable court.